Well, good afternoon, ladies and gentlemen, and welcome to People Hour from gunnercooke, our inaugural webinar giving you an update on key employment law developments over the last month. My name's Simon Horsfield, partner in the employment team here. I'm going to be presenting to you today. In future seminars, you'll be hearing from other members of the employment and pensions team. So in terms of our format for these sessions, the idea is we're going to always speak at 1 o'clock on the first Tuesday of the month, so people can make that a regular diary entry. We will send invites round each month as we have done this time. We will be speaking for up to 1 hour, so the invite will be an hour, but we're not just going to fill that time needlessly. If it happens to be a low news month, we'll just keep it to a short session. So we'll just play that one a little bit by ear. One thing I would like to draw your attention to, if you have a look at the dashboard in the top right hand corner of your screen, you'll see that there is a question facility. I think that's a really useful feature of these webinars, and I would encourage people as we go through to post questions. I'll be looking out for them coming in. I'll pause my presentation, deal with the particular question, and then move on. So I would encourage people to use that, please, as they see fit. We are recording all of these sessions, and a recording will be made available on our website after the event, and that's an opportunity, if you can't make the live webinar, to access that afterwards and listen to it at your leisure, or if you miss a point and want to listen to it again, that could also work. And of course, finally, if there's other people in your organisation you want to share this with, you can draw your attention to the recording on the website. One thing we're quite keen to explore in the future, depends a little bit on the appetite of people on the other end of the line, is whether we should have live events. We could host a live People Hour session here in Manchester or in our London office with the webinar broadcast simultaneously. The advantage, it seems to me, of having the occasional live event is it's just an opportunity for you guys to network with your peers and share a few ideas. Just one housekeeping point from me: if you are dialing in by telephone rather than using the audio equipment on your computer, if you could mute your phone at your end, that would be of much assistance. And then the final point to note, CPD will be available, and technically we can only make it accredited CPD if the session lasts for an hour. So it's up to you really in terms of how you want to go ahead recording your CPD time for this. So let's move on to the actual presentation. In terms of the topics that I wanted to cover today, I wanted to start by looking at shared parental leave, because this is a significant change in the law that's going to come into effect from next month. And allied to that, I want to just touch on the new right to time off for employees to accompany pregnant workers to antenatal appointments. There's been a really interesting TUPE case on service provision changes that I think it'd be worth us just spending a little bit of time unpicking. I want to just recap on where we're at with flexible working, and then I want to finish by looking at the very topical issue of holiday pay, the initial focus being on holiday pay and how you deal with commission payments based on the Lock and British Gas case, but I think it's also only appropriate that we update you on the decision of the EAT that's just out this morning on the Bear, Scotland and Fulton case, which we'll come on to, and that's the one that looks at voluntary overtime. So let's start with shared parental leave. So this shared parental leave is a new statutory right giving parents flexibility in how they share the first year of their child's care. And you might remember this was something that was trailed a good few years ago by the coalition government, something that they wanted to look at bringing into effect as part of their commitment to helping working families. One point to note, as this piece of law is being brought in, so the statutory right to additional paternity leave is being abolished, and that's because this right effectively replaces that. But importantly, statutory maternity leave and ordinary paternity leave remain unaffected. So we still need to have in mind obligations under those respective pieces of legislation. So when is this new law coming into force? I mean, it's due in on the 1st of December, and my view is it will almost inevitably impact your business. So we do need to be just thinking through what it means. Whilst it becomes law on the 1st of December, it's actually only going to be applicable to babies who are due to be born or children who are due to be placed for adoption on or after the 5th of April 2015. And the reason for that delay is because there are certain notification requirements and time needs to be built in advance to allow those notices to be given. So we think that employers will start to receive notices of intentions to take shared parental leave from the new year, from January 2015. Now, it's a right that is available to parents of children. It's tempting to fall into the trap of thinking of that as mother and father, but of course that's wrong. It's a right that also extends to same-sex parents. But for the right to be available, the mother of the child must be entitled to take maternity or adoption leave, or statutory maternity or adoption pay or maternity allowance, and they must share the child care responsibility for the child with their partner. Now, parents who are seeking to exercise this right must have worked for their respective employer for at least 26 weeks at the end of the 15th week before childbirth, and the parents must have earned an average salary of at least £111 for the 8 weeks prior to the 15th week before childbirth. And the whole reason for this is that the government, in response to consultation, wanted this right only to be available to parents who are, in inverted commas, economically active. Now, actually, that definition means that an individual might be self-employed, or they might have recently ended work, but still be eligible to exercise this right. So we've got to think of it in broader terms than just those who are in active employment at the current time. Now, in terms of the process for exercising this right, it's incumbent on the respective employees, the respective parents, to notify their employer of their desire to take shared parental leave and to inform them of the dates that they wish to take that leave. And the notice must be given at least 8 weeks before the leave is due to commence. It's a right that's only available for the first 52 weeks following the child's birth, and that's obviously to reflect the ordinary and additional maternity leave periods. And the amount that can be taken is 52 weeks less any maternity leave that's been taken. And on that point, it's important to remember that 2 weeks is compulsory maternity leave, so that can't be sacrificed by a mother in favour of the father. Now, in terms of taking periods of leave, the leave can be taken in blocks, which means that the employee can serve a number of notices during that 52 weeks following the child's birth. And to prevent abuse of that process and frustration, I guess, for the employer, the government has decided that an employee can only give up to 3 notices. Just notice that we've got a question, so I'm going to pause there. And the question is, how does this right affect part-time workers? Now, I'm going to answer that on the basis of those part-time workers being employed by the organisation. This is a right that does extend to those part-time workers in the same way as maternity leave, ordinary and additional, is available to a part-time employee of an organisation. So shared parental leave will be available to part-time employees in both the mothers and the partners organisations. Follow-up question, what if they do not earn £111 per week as a part-time worker? If they're not earning the requisite amount to meet that threshold, then they're not deemed, unfortunately, to be economically active, and therefore they do not qualify for shared parental leave. The mother would still qualify for her ordinary and additional maternity leave and potentially maternity pay, depending on her entitlements in that regard, but shared parental leave won't be available. So we were talking about notices that need to be served on an employer. We've said up to 3 notices, which can either allow the parents to take the leave simultaneously, in aggregate up to the 52 weeks less maternity leave. It can allow the mother to return and for her partner to take the balance of her leave, or it can allow for the couple to take leave in turns, the kind of tag team parental leave approach. So I think the important points to remember for the HR teams to feed back into the business, it's very important to remember that leave can be taken in blocks, but effectively we're limiting this to 3 blocks of parental leave because of the requirement for up to only 3 notices. Remember the requirement for that 8-week notice to be given, and remember also that if the proposed leave is discontinuous, so we're not talking about a block, but we're talking about a staggered approach to leave, then that can be pushed back and a discussion can be engaged in with the individual if those dates aren't suitable for the business. Where it's a block or it's continuous leave, it can't be negotiated. It's only where we're talking about discontinuous leave. I've just seen another question pop up. Another 2 questions. If I have a mother working for me and the father works for a different company, how do I know what proportion of leave the father will be taking and therefore how much leave the mother is entitled to? Well, that's all set out on the notice. There are certain requirements that the individual has to satisfy when they serve their notice of shared parental leave, and that sort of information will have to be included in the request. Next question, what if a baby is due on the 5th of April but is born on or after that date, or a baby is expected on or after that date is actually born earlier? Now my recollection of this is that the key is what is the expected date of that baby, but if it's therefore born earlier, my view is, although I'd need to just look in the detail of the regulation, but my view is that the new law would apply even if circumstances mean that that baby is born earlier. So the key is going to be what's the expected week of confinement for that particular child. Okay. For me as an employment lawyer, I think that the kind of procedural elements of shared parental leave kind of look after themselves. If you're in any doubt about the procedure, there are some really helpful process notes on the ACAS website, and we've included the link to that in this presentation. And I guess from your perspective as HR professionals, making sure policies and procedures are up to date is going to be really important, and making sure that line managers understand a business's new responsibilities and perhaps embrace a change in mindset when we're talking about fathers and other partners who are going to be wanting to take potentially more significant chunks of parental leave. I think those are kind of interesting points from an HR perspective. What really gets me going now is thinking about what are the legal implications and potential consequences of this. And I'm particularly thinking about where the organisation that a father works in offers enhanced maternity pay. Will they have to offer enhanced pay to the father who wants to exercise their right to take parental leave? And that's a point that I think is very much up for debate. It's been looked at in the Shooter and Ford Motor Company Limited case in a slightly different context, and it of course is a whole question around how will discrimination legislation be interpreted in these circumstances, and to the extent that it's indirectly discriminatory not to offer fathers, enhanced pay in these circumstances, can the employer justify that approach? And I think that's a really interesting area of law that we're going to see develop through the coming months. Important also to remember that there is protection not just for the mother now, but also for the partner of that child in terms of not being subjected to a detriment and in terms of not being dismissed, and it will be automatically unfair to dismiss a partner on grounds that they have sought to exercise their right to shared parental leave. Okay, I'm going to move on from parental leave and look briefly at antenatal appointments and just talk about the new right. It came into effect last month, actually on the 1st of October, and this is a right for an expectant partner to take unpaid time off to accompany their pregnant partner to up to 2 antenatal appointments lasting up to 6.5 hours each, and that includes travel and waiting time. Now, this entitlement applies to employees and agency workers where they're in an enduring family relationship, that's the terminology from the legislation, with the mother, but it doesn't include relatives. Length of service is irrelevant, so this is a day one right, and it also is a right that extends to parents of a child born to a surrogate mother. In order to request that time off, the employee must give notice to the employer, and there's certain prescribed information that has to be included in that notice. So, for example, that the individual is the partner of the mother, the reason for the time off, i.e. to accompany to an antenatal appointment, that the appointment's been made on the advice of a medical practitioner, and obviously you have to give the date and time of the appointment. Now, there's no set procedure being laid down, no default procedure. It's very much for the individual employer to decide how they want this to work, whether it's a formal or informal approach. But it seems sensible to me to include this right in a policy, setting out the process that you expect to be followed, the information that you require, and what constitutes reasonable notice. I think it would also be important to spell out that you reserve the right to refuse a request where it's reasonable to do so. But I would just flag that there is a risk, of course, with refusing requests on an unreasonable basis, because it could lead to employment claims. As a minimum, the individual can claim up to twice their hourly rate at the time that they should have been allowed to take off. Not particularly concerning, I suspect. But I think the bigger issue really is around the wider employee relations piece. If you start consistently depriving people of these rights, and the potential for their grievances and ultimately constructive dismissal type arguments to be brought. Okay. Let's change tack completely and look at TUPE and this decision on service provision changes that I referred to in the introduction. So it's a decision in Costain Limited versus Armitage and ERH. And here we have the typical service provision scenario where you have a client who has contracted out a particular activity to contractor A, which was ERH in this case. They've decided they're not particularly happy with contractor A, so they want to substitute contractor B, which was Costain in this case. And as we all know, that is classic service provision change TUPE territory. And in this case, the particular question was which employees are in scope to TUPE transfer. And Armitage, who was the claimant, was employed by ERH as a project manager 3 months before ERH lost the contract. He was effectively promoted onto working on the All Wales Regional Maintenance Contract, which was one of these big framework agreements with lots of separate call-off contracts underneath it. But as well as working on that big contract, he kept dealing with some other work on another project that ERH were dealing with, looking after the Welsh Assembly. Now that regional maintenance contract, the Welsh regional maintenance contract, went up for tender, and ERH lost that contract to Costain. So parties all agreed there was a service provision change. It took place on the 1st of February, and a number of employees were in scope to transfer from ERH to Costain. The Welsh Assembly work remained behind, so as you'd expect, those employees who were dedicated to the Welsh Assembly contract stayed with ERH. And the question was, whose employee was Armitage as a result of this service provision change? ERH said, absolutely not our problem, because if you look at the period since he was promoted to that regional maintenance contract, the statistics show that he spent 67% of his working time on that Wales regional maintenance contract. The balance of time he'd spent doing the stuff on the Welsh Assembly contract. And as we all are inclined to do, you tend to think that if someone is spending the majority of their time, which clearly only needs to be 51%, working on a particular contract, then they're going to be in scope to transfer. And that was what ERH argued. Costain weren't happy with that approach. They didn't feel they needed Mr. Armitage, and so they sought to argue that he wasn't assigned to that regional maintenance contract and didn't transfer, but actually he was ERH's problem. The tribunal at first instance was very, very persuaded by the statistical evidence that ERH put forward, and this 67% clearly resonated very much with the tribunal. And they found that because of that, Armitage was essentially dedicated to the regional maintenance contract and that he should transfer to Costain. Costain then appealed. So this went to the Employment Appeal Tribunal. And the basis of Costain's appeal was that the tribunal had applied the incorrect test and they placed too much emphasis on this percentage point, this 67%. Now, in terms of the incorrect test, what Costain said is that the tribunal should first have asked themselves, was there an organised grouping of resources which was dedicated to looking after the All Wales Regional Maintenance Contract? And only having satisfied themselves that there was that organised grouping should they have then gone on to ask the second question, which employees were assigned to that grouping. Now I think everyone accepted that really there was an organised grouping, but the Employment Appeal Tribunal in their judgment did say that the tribunal should have gone through that process and they should have shown more analysis of that first stage of the process before going on to answer who is assigned to that organised grouping. So that's interesting in itself, just a useful reminder for us to always start with the question, is there an organised grouping in the first place? Then when looking at who is assigned to that organised grouping, the Employment Appeal Tribunal said that percentages can be helpful, but they're not the be-all and end-all. And we've got to go right back to that European case that you may well have heard us talk about, this Botson decision that says actually it's a much more sophisticated question than a percentage test. It's a question of what's the most important element of what that person does in their role, what do they consider to be the most significant part of their duties, can play just as much a part as how much physical time they spend on a particular activity. And also, the Employment Appeal Tribunal said we can't take artificial snapshots in time, so we can't just look at the position at the point of transfer. We've got to look at the employment relationship as a whole, and it was very artificial to focus on those 3 months preceding the service provision change after Armitage had been promoted to that regional maintenance contract job. So they didn't actually give a decision on whether or not Armitage should have transferred. They pushed that question back to a tribunal, so that issue will have to be reconsidered at a later date. But they gave very clear guidance on the fact that don't focus too much on percentages and don't have a distorted view based on just a snapshot in time. Always look at the bigger picture. Now, in terms of how we can use this decision to help us in our day-to-day jobs, it seems to me that keeping records, particularly for senior employees, of the work taken when they're dipping in to lots of different activities and different contracts is going to be a useful part of the process in terms of helping you to identify whether they're in scope or not. You can't just go on your gut feel. You need some evidence to back that up. I think there's also an argument to be said for building into contracts an obligation on the outgoing contractor and the incoming contractor to spend a bit of time cooperating in good faith to identify which employees are in scope to transfer. And it seems to me that that cooperation requires the outgoing contractor to share that information about what the employees have done and how they've filled their time. Now, in my experience, the outgoing contractor isn't going to do that voluntarily, so that's the sort of provision that needs to be built into a contract. You need a bit of foresight to build that in so that that dialogue happens at the point of the service provision change, which could be 3-5 years down the line. But that's, I think, the most practical recommendation I can give. Without that, you're just reliant on voluntary sharing of information by the outgoing contractor. Okay. Let's move on to flexible working and just take stock of where we are. So this, as you'll know, is a new statutory right for all employees. You've got 6 months service or more, and it's a right to request flexible working, flexibility as to hours, times, place of work. So very similar principles to those that we had previously, the only difference being at a high level that this is now available to all employees, not just those with childcare and responsibilities. Also, very significant to note that the procedure is less rigid, far less rigid than it was previously. So we don't now have to follow that statutory procedure and print off the forms from the government website and everything else. It's just triggered by the employee making a request. You then got 3 months to consider that request, discuss it, and give your decision. You can still refuse the request, and the statutory reasons for refusing that request remain the same, business needs and all that kind of stuff. The only obligation on you is to deal with that request in a reasonable manner. And on that point, I would just flag the ACAS code, because I think that will be taken into account by tribunals in deciding whether or not you've behaved reasonably. Things like offering the individual the right to be accompanied, I think go to reasonableness in this context. It's still the case that only one request can be made in any 12-month period, and it's still the case that an employee can claim if they feel their statutory right has been infringed, and where there's been unreasonable conduct on the part of the employer, they can claim a maximum award of 8 weeks' pay. So again, not the most significant or scary in terms of risk profile for the business, you might think. But what I would say, just jumping down to the final bullet point on this practical implications slide, is the need to be aware of indirect discrimination claims that can arise out of a failure to grant a request. And I'm thinking here particularly of claims for associative discrimination. So an employee who puts in a request to work flexibly because they want additional time to take care for a disabled child, for example. We had a case on that just probably 12 months ago, which said that the equality legislation duty to make reasonable adjustments doesn't extend to associative discrimination. These flexible working provisions will, though, and I think that could be an area that we'll see develop more and more. Other practical implications, I mean, I think looking at a number of the people who have signed up for this webinar, I think you'd already extended this right to flexible working to all employees, in which case I don't think any significant changes. But for those employers who haven't, again, I think it requires a change in mindset, particularly amongst the line manager community. So it seems to me that's all about raising awareness and supporting that with training. And I think if they haven't been already, policies and procedures do need to be updated, and line managers trained in how to respond to these requests, not least because of the risk of associative discrimination claims, as I've flagged there. Okay. So, come to our final topic for today, and it's holiday pay and commission. And I'm thinking here about the Locke and British Gas case, where a decision is expected imminently, as we'll come on to. And just to remind you of the facts in this case, Mr. Locke, employed by British Gas as an energy sales consultant. As with lots of employees in all different industries and sectors, Mr. Locke is employed on the basis of basic salary plus commission, and that commission in his case is on sales that he generates. As is often the case, the commission can be paid many months after the sale is concluded, and in Mr. Locke's case I think it was around about 3 months time lag between the sale concluding and the commission becoming due and payable. But commission for him was a very, very significant part of his earnings, and the evidence was that it actually makes up 60% of his wages. So Mr. Locke was on annual leave between the 19th of December in 2011 and the 3rd of January 2012. And during that period, he received holiday pay, which was calculated by reference to his basic pay, plus he received commission, which had become due and payable from sales that he'd made 3 months previously. So for the period of that holiday, he didn't seem to be out of pocket. But what then happened, of course, was he'd had 3 weeks out of the business when he hadn't been achieving any sales. And 3 months down the line, in March, April 2012, his pay dipped markedly, probably by about 60%, because he only received the basic element, because no commission was coming through at that time. And cleverly, cheekily, whatever way you want to look at it, he put in a claim saying that actually his holiday pay back in December 2011 should have been topped up to offset the losses that he was going to suffer 3 months down the line. Okay? That claim went to the tribunal, and it was a claim for unpaid holiday pay. The tribunal agonised over this, scratched their head for a while, and decided to stay the claim and refer the matter to Europe in accordance with a long line of holiday pay cases that have been referred to Europe. That's very much the on-trend thing to do. And an opinion was sought from the European Court. The Advocate General gave his opinion first, and the European Court has subsequently agreed with that. And they concluded that the holiday pay that he received in 2011 should have included an element of top-up to take into account the commission that he would have earned if he hadn't taken his holiday. And that top-up element was payable at the time he was getting the holiday pay. So there'd be an artificial credit to offset the period 3 months down the line when he wouldn't be earning. That was the way that the European Court and the Advocate General felt it should be done. Now, in terms of calculating the element of that top-up, Advocate General gave an opinion on this point and said that actually he felt it should be based on average commissions earned over the preceding 12-month period. But that was just an opinion. So that element isn't binding, but that question is going to have to be answered when this matter is considered by the tribunal. So the case has now been referred back to the Employment Tribunal. The European Court, of course, is giving its view based on an interpretation of the Working Time Directive. So the tribunal now has to read the Working Time Regulations in accordance with the approach that the European Court takes to the Working Time Directive. That hearing took place just a few weeks ago, 20th and the 21st of October, and we're expecting the judgment at any time. Most commentators, in fact all commentators that I have seen, are saying that it is very, very likely that the tribunal will find that the Working Time Regulations will have to be interpreted in the same way as the Working Time Directive. And even if that involves rewriting the Working Time Regulations, we've seen that's what tribunals are prepared to do. So, if you have employees who are earning a mixture of basic pay and commission based on sales, then it seems to me that you need to be ready for the fact that this decision may come in, and it may well mean that you have to change your approach to calculating holiday pay, and that this could be a significant cost to the business. As we say, we don't know exactly how that's going to be calculated, but if it follows the Advocate General's opinion, it's going to be based on a 12-month average. There's clearly the potential for the floodgates to be opened, and that's why these holiday pay cases are making the news at the moment. And people are talking scary numbers in terms of the potential liability for back pay. The limitation point, of course, is relevant here. If this is a claim for unlawful deduction from wages, as it's most likely to be, then the time for bringing that claim is 3 months. But a lot of commentators are suggesting that this could be dealt with by way of a series of deductions, in which case the time limit just continually rolls forward, so it's 3 months from the last in the series of deductions. And in theory, that really could open the floodgates to claims going all the way back to 1998, when the regs were first introduced. I have to say, I think that's unlikely. this whole floodgate point is being looked at in another holiday pay case, the Wood and Hurtle issue, and there's been a submission made by the Secretary of State for Business that the maximum back pay should be 6 years, which is in accordance with contractual liability issues. And so my gut feel is that worst case scenario, we're probably looking at 6 years worth of back pay. There is also an argument which has just been aired recently, and I'll come on to it in a moment, but there's also an argument that, of course, when we're talking about holiday pay, there isn't a series of deductions at all, because each time holiday pay isn't paid, that is an omission, and the 3-month time limit starts from that omission. And given that there will often be quite a few months between successive holiday requests, you could argue that it's stretching the point to say that there's a series of deductions there. But these are all technical legal points that we don't have any guidance on at the moment, save for one point that I'm going to come up to. And that point is this final reference to Fulton and Bear, Scotland. Another holiday pay case, but this time looking at voluntary overtime. Don't know about you, I love it when employment law makes the news. I woke up this morning to Radio 4 talking about this issue. It's been all over the BBC website, and it's the whole question of, similar to the Commission point, where someone works voluntary overtime in the period preceding a holiday, should that voluntary overtime be factored into their week's pay when you're calculating their holiday entitlement? And the slide there says the judgment's expected today. Stop the press, because that judgment did come out about 2 hours ago. I've not had time to look at the judgment in full, but what I can confirm is that the Employment Appeal Tribunal has said that normal, non-guaranteed overtime should be included in holiday pay when you're calculating what somebody's week's pay is. So there will have to be an exercise to be done in terms of averaging out earnings in the preceding 12 weeks to work out what holiday pay should be based on any additional voluntary overtime. It seems that the Employment Appeal Tribunal is saying that this is limited only to that portion of holiday pay that is the basic entitlement under the Working Time Directive, i.e. the 4 weeks leave, not the additional 1.6 weeks granted under the Working Time Regs. And the Employment Appeal Tribunal seems to be suggesting that the time limit runs from each successive period of holiday, and that it shouldn't be treated as a series of deductions. And if that's right, and if I'm reading that right, I say I need to look at it, then that really does help to shut the floodgates, on all of these holiday pay claims. But I think there will still potentially be a significant liability lurking around where people have taken holiday in the last 3 months, and we're still probably just in scope for this summer holiday just gone for people to put in claims. So it seems to me that, if nothing else, businesses should be flagging this issue with the Finance Director, CFO, because it's a potential significant liability that they may not have thought about, although if they've been listening to the BBC today, it'll be on their radar now. And then an audit needs to be undertaken to work out just how much of a risk is this for your business. I think we need to be thinking quite creatively about what other elements might people seek to throw in here, as well as voluntary overtime. What about travel allowances, attendance bonuses, all those kind of things that are intrinsic to the role that they are performing, that they might want to see included in a week's pay for when holiday is actually claimed. So I think this is still a significant issue. I think the Fulton and Bear Scotland case helps in terms of potentially limiting the back pay element of this. But in terms of identifying an approach for going forward, you need to know whether there's a problem first of all, and then if so, come up with a solution based on how do you average out someone's pay to work out what the correct holiday pay rate is at the point that they're taking that holiday. Okay. That's all I wanted to cover in this first session. My details are there if you do have any questions that you want to pick up with me separately or require any further advice. But of course what I would say is do go first to your usual gunnercooke contact who will be able to help you on this point. That's all from me. I'm interested in getting feedback from people, so please do let us know what you think about People Hour as a medium for updating, whether it works for you, whether you'd be interested in attending a live People Hour session, do let us know. And if you think it's been a useful experience, then I'd ask you to spread the word, because we're more than happy to invite as many people as want to join, and this is open access. So by all means, ask people to get in touch with us so that we can let them have registration details for future events. At our next session, we'll have a different member of the team presenting. An invitation will come out with the details of when that is, but as I said at the beginning, it's always going to be on the first Tuesday of the month at 1 o'clock, and we look forward to seeing you there. I'm going to close this session down unless anyone's got any questions that they want to post. So nothing's coming through, so let's draw this one to a close and look forward to seeing you in future sessions.